Hello again, everyone. Again, my name is Dylan Moench, and I'm Legal Representation Director here with the Children's Commission. And I'm here with part 2 of our presentation on procedural justice for the background materials for the Judicial Trauma Institute. In part 1, we learned a little bit about the research and the concepts behind procedural justice. And in part 2, I want to talk a little bit more about concepts and about how they relate to CPS cases. So where we left off in the last video is that we had identified 4 key components that people associated with a fair procedure. And those concepts were voice, respect, neutrality, and trust. And I want to talk a little bit about each of them, and we'll begin with voice. And what the studies reveal is that when people were defining voice, what they meant was they really wanted an opportunity to tell their own side of the story in their own words to the decision maker. And people wanted this opportunity to have this voice before the court made their decision. And again, I imagine there's a lot of attorneys who are having some heart palpitations about judges speaking to the court directly out of concern that they may do something detrimental to their case. And that's certainly a legitimate fear. But what I'm asking attorneys to do is to not let that fear simply stop the conversation about trying to find ways for parents to find voice. Because no matter how good the attorney is, no matter how well prepared they are, no matter how articulate they are, no matter what the strength of the argument they make, that well-prepared attorney might satisfy the court, but being left out of the process, feeling you're sitting there silently experiencing what's happened to you, you don't have any of your own say in what's going on, may not satisfy the child or the parent as they go through the CPS case. And we know this because there was a survey done by the American Bar Association on youth who attended CPS cases. And what the youth reported is they really wanted judges to hear their own voices. And they wanted to be able to provide direct input about their situations to the judges. And unfortunately, a majority of youth surveyed feel like they didn't have a voice, but they really wished that they had. And the youth really wished that judges would ask them directly about their wants and needs and placement, even if it was submitted privately or submitted in writing. So this tells you some of the values that particularly youth have on having their voice heard in the court process. And this is not just true for judges, it is also true for attorneys. This was a question that was part of the Children's Commission 2018 study on legal representation, where we asked youth in CPS care how they felt about their attorney or how having an attorney made them feel. And what you can see is the feelings that children most strongly associated with having an attorney, the positive ones were, they felt important because attorneys listened to what they had to say, or they felt positive because their attorney helped them understand what's going on. Again, those are concepts strongly correlated with voice, whereas the concept associated with getting the outcome they wanted, having an attorney help them getting something they wanted, had much lower correlation for youth as far as how they felt about their attorney. So these are concepts that are not just related to judges, they're also related to every single interaction that parents and youth have with the justice system. So what are some action steps that can be done to enhance this sense of voice? Well, courts can work on providing an opportunity for parents and youth to address the courts directly. For attorneys who are anxious about that, maybe that's something you prepare with your client in advance, exactly what the judge, what they're going to be able to say to the judge. Courts may consider allowing parents and youth to speak first at hearings before the professionals report on the family's process. When interacting with parents and youth, using open-ended questions and really listening to answers, as well as providing other forums as part of the process where people can have a much more enhanced sense of voice, mediation, family group conferencing, or family team decision-making that really allow that voice to be heard. And also for courts, seeking regular feedback from families about the court process and what they would like to see done differently. So the next concept that I wanted to talk about is neutrality. And the important thing about neutrality is that when we're talking about it in terms of procedural justice, it's not simply that the decision maker be neutral, it's that the decision maker is perceived as neutral by the people who are before the court. And what that means is neutrality can't be assumed, it has to be demonstrated. And what people are looking for when they to identify whether or not the courts are being neutral is they're looking to whether or not decisions are based on facts and on rules and not personal opinions, and whether or not those rules are then consistently applied across people and over cases. So what are some steps that courts and court personnel can do to enhance this sense of neutrality? One thing is to just clearly state the court's rules in a respectful and transparent manner. May have them posted either outside the courthouse or possibly inside the courthouse. Explain how and why decisions are made. Again, explain not just that a child can't return home, but why a child can't return home and what are the rules and the facts that necessitate that decision. Taking care to avoid the appearance of favoritism. This is something that's particularly difficult, I think, for a lot of professionals who have close relationships with other professionals in the field. It's natural to be very friendly and open with them as part of the court process, but it's important to think about how that looks to everyone who's waiting to have their case heard. If there's this appearance that parties are favoring one party over the other, or possibly favoring their own relationships over that of the people in front of the court. It's also important to create courtrooms where the judges, parties, and the professionals are seated either in a circle or as equity as possible. And when you're making decisions or making rulings, such as identifying what requirements you're going to approve for the service plan, have those be visible. Maybe write them on a dry erase board or have them visible upon a computer screen in addition to stating them out loud, because that enhances the sense of transparency and neutrality that people experience as they're going through the court process. So this may sound, again, that they're little things, but they do make a difference. And we know this because there was a Minnesota court study where they randomly assigned cases. Some decisions were just announced, and some took the extra time to explain the decision, how it was arrived at, and what rules guided that decision. And the courts that took that time, it resulted in greater satisfaction with the court and higher acceptance of the court's decisions. So the next component I want to talk about is respect. And what people are really looking for is respect for themselves as people and as citizens who have the right to have the court address their concerns and have those concerns taken seriously. And this is true irrespective of whether or not they have a strong legal case. And as we know, many parties in CPS cases may not have a strong legal case, especially at the beginning, but they still have concerns and they still have things they would like addressed, and they still want to be treated with respect when they vocalize those concerns. So what are some action steps that courts can do to demonstrate respect for the people? Well, a very simple one is taking the time to use everyone's proper name rather than mother or father or respondent or parent or kid or kiddos. Taking the time to actually identify the individual person. That's very meaningful, and we'll see some studies later that actually back that up. So another thing you can do is value people's time. Start court hearings on time, and if you are late, provide an estimate of wait times to people who are waiting for court to start. If there are lengthy delays, and we know sometimes that's out of the court's control, it doesn't hurt to apologize to those who are in front of you for those lengthy delays, because that honors their time and their lives. When you're scheduling hearings or scheduling meetings, ask about a parent's availability. Include them as an equal participant when you're trying to manage everyone's time. You can also do things that respect their rights, including just simply giving people information about what their rights are. Perhaps posting the foster child's Bill of Rights inside the court, or providing pamphlets or leaflets that explain basic rights. The Children's Commission has materials regarding what a parent's relationship with their attorney should look like, and for foster parents, what a child's relationship with their attorney should look like. You can also emphasize to them that they have a right to bring their problems to court, and when they do, that those problems will be dealt with in a fair way. You can also tell them how to complain to higher authorities. And again, this may be something that gives judges and attorneys a lot of pause. Nobody wants to have their decision overruled by a higher court, and no attorney wants to have an action filed against them. But explaining that to people, that option exists, is in a way empowering them and also demonstrating to them confidence that you're not concerned about that, because that's part of the process that you know is fair. And importantly, the right to complain and understanding that and having that explained to you is actually much more important to people than actually making complaints. The next factor I want to talk about is trust, and sort of the central factor that people are looking for to identify whether or not they can trust someone is they're trying to assess their character. Is this person sincere? Are they caring? And what people are trying to do when they assess a person's character is they're trying to identify, is this person really listening to and considering everyone's views in front of them? Are they really trying to do what's right for everyone involved? And are they acting out of the interest of all the parties and not some personal prejudice? So what can you do to enhance this sense of trust in the people who are coming before the court? Well, a simple thing is creating a welcoming environment in the courthouse. Courthouses, as they are sometimes designed to establish a sense of awe or importance, but that can also be very intimidating for a lot of families. So as much as that can be done to make the courthouse welcoming and family friendly, it can really enhance that sense of trust. As much as you can, situate the judge's bench at eye level. Make sure that you are doing as much as you can to create an equitable atmosphere between everybody who's before you. Introduce yourself by name. You want to make sure that you know that they are a real person and that they know that you are a real person. Simply ask them how they are doing at the beginning of each hearing. And when you interact with someone, make sure that it's personal. Make extra effort to maintain eye contact when you're talking to somebody or talking about them. You can also take steps to make sure that you have trustworthy interactions. And that means when you are talking to people, give evidence to them that you are listening to them. Acknowledge their needs and concerns, even if you can't base your decision on them. Express awareness and empathy for their situation. A lot of people are in very difficult circumstances trying their best, and simply acknowledging that can go a long way. Take adequate time to consider arguments when making decisions. Even if you know what the decision is going to be, if you make that decision appear perfunctory, then people may not have as much respect for that decision. When you do make your decision, explain it. Demonstrate in your announcement of the decision that you considered people's arguments by referring to them. If there's unfairness that you simply can't eliminate or control, it doesn't hurt to acknowledge that. And at the end, simply asking if people have questions can do a lot to enhance people's sense of your trustworthiness as a decision maker. And the key theme to all of these 4 factors is that you have to show your work. It's not enough to simply value someone's voice, to be neutral, to be respectful, and to be trustworthy. All of these things have to be demonstrated to the people in front of the court so that they believe that they're real, that they perceive them as real. That's the key. It's not enough to have them in your head or in your heart. They have to be communicated and demonstrated to the people in front of the court to have the value. And we know that these things can actually affect the outcomes of cases. There hasn't been a lot of research on procedural justice as it's tied to CPS cases specifically, but there was a Nevada 2018 Supreme Court hearing observation study. And what they did is they measured a lot of the sort of the concepts and the court behaviors that we're talking about, and they measured them against how they correlated with certain permanency outcomes. And what they tried to identify was how the court engaged the parties, and they define engagement by explaining the purpose of the hearing, to speaking parties directly, addressing people by name, asking if they have questions, identifying next steps, asking if people understood the next steps, and making sure that people had an opportunity to be heard. So those are sort of the things they broadly defined as engagement of the parties. And as you can see, when courts engaged with the parties, it resulted in a decreased time to permanency, an increase in reunification, an increase in permanency within 12 months, and a decrease of children aging out of care. And I want to circle back to one specific finding is just the simple act of referring to the mother by her name, by her proper name rather than as mom, was associated with a decreased time to permanency. So I want to highlight that as just a little thing that can go a long, long way in affecting outcomes in CPS cases. So how do we implement these changes? Well, this is really a systemic approach. So when people are evaluating the legitimacy of the justice system, they're evaluating every experience they have with the justice system, whether it's as a litigant, as a juror, or even being stopped by a police officer. So every single interaction is part of their evaluation of this experience. So for courts, that means that you should try to incorporate procedural justice concepts at all stages of court interaction. That can be at the court help desk, people's interaction with the bailiff, the judges, attorneys. All of these interactions matter. And we've taught a lot about interpersonal treatment, and that's critically important, but it's also important to establish some changes in objective procedures that incorporate these concepts, because that can sort of heighten the level of fairness that is routinely experienced by everyone who comes before the court. Now, the good news is that these changes are actually pretty inexpensive. There's a lot of things to buy or really do. These are just changes in how people interact. Now, they do take time, but as you can see, that time has a lot of benefit in the fact of how it can change the permanency outcomes for families. And importantly, these are low-cost changes that can actually have a very high impact for the families that are in front of you. So this has been our explanation of procedural justice and how it relates to CPS cases. If you have any questions, please don't hesitate to contact me. I'm happy to answer questions over the phone or by email if I can. I want to thank you for your time, and I hope everyone enjoys the Judicial Trauma Institute. I know that there's been a lot of hard work that's gone into it, and it will be a tremendous resource for courts all across Texas. Thank you.